I was discussing with the panel the makeup of the audience, and we were discussing how many of you are legal experts versus those who just are interested in this. So I'm curious, how many of you have law degrees?
Uh-oh.
Oh boy. How many of you are actively practicing law? There we go. Okay. Thank you.
Expert crowd.
Expert crowd.
Yeah.
About law students.
Students. I know we have some students in the audience as well.
I was hoping we could fool the audience, but maybe not this time.
We might actually have to be accurate.
You can still try. Don't give it away, David.
You ready for us? Mabel, if you want to take your spot, you want to give her a cue, or? Okay. On your cue.
Okay.
We're going to get this in place, and then we'll go. Okay.
We
On your
good?
cue. Yep.
Good afternoon. We're pleased that you've been able to join us for this afternoon session. I'm Mabel McKinney Browning, Director of the American Bar Association's Division for Public Education, and it's my pleasure to welcome you to our annual public program, On the Docket. We are once again pleased to be hosting this program in partnership with the Woodrow Wilson Center. This panel, as you know, is made possible through the work of the division's premier publication, Preview of United States Supreme Court Cases. And you all have a copy of our issue 8 roundup from the last term. Preview benefits from a very special and unique relationship with the U.S. Supreme Court, journalists, and law professors across the country. Today's panel includes members of the Supreme Court Press Corps and well-respected scholars and Supreme Court practitioners. I'll leave it to our moderator, John Malusky, to introduce our panelists, but let me take this opportunity to thank them for their time and their efforts in participating in this program. We always appreciate their support. Now, just for a quick note about John himself, John is the host and managing editor of the Dialogue television and radio show here at the center. He is also a long-term friend of mine and the ABA's Division for Public Education, and we are very pleased anytime that we're able to use his very able and marvelous moderating skills for one of our programs. So thank you, John, and thank you.
Thanks very much, and welcome everyone to the Woodrow Wilson International Center for Scholars, which happens to be our nation's living memorial to its 28th president. And how many of you have been here before? Most of you, but some of you who haven't. Let me just say a few words about the center and welcome you on behalf of our director, Jane Harmon, and all of my colleagues here. This is a place where deep research takes place in order to inform the public policy debate. It's also, we'd like to think of it as a safe harbor for informed discussions about pressing issues that too often are left to partisan forums where it devolves into bickering and silliness. And so we're hoping that this is a place where people can come in this town of all political stripes and have a more meaningful dialogue. And so thank you for joining us in that cause today. And we, as Mabel expressed from the ABA's perspective, we also are very happy to once again be working with the ABA's Division of for Public Education on this On the Docket annual event. And each year we provide you with a preview of the upcoming term, and it certainly has been an eventful number of years and looks like it will be once again. As always, the ABA assembles a stellar panel to help us navigate these waters, and I'm going to briefly introduce them to you now. The longer bios are in your programs. From your left to right, Renee Landers is an associate professor at Suffolk University Law School. Previously, she served as Deputy Assistant Attorney General in the Office of Policy Development at the Department of Justice. She's also a past president of the Boston Bar Association. David Sammons is a partner with the law firm Bingham McCutcheon, where he chairs the appellate practice group. Previously, he served as an assistant to the Solicitor General of the United States, and he's argued 14 cases before the Supreme Court and has lived to tell about it, and is here to join us again. David Savage is the Supreme Court correspondent for the Los Angeles Times. Previously, he provided legal commentary for National Public Radio's Talk of the Nation, and along with me is one of two non-lawyers on this panel. and Stephen Wormeal. Steve joins us. He's a professor with the American University Washington College of Law. He is co-author of a biography of Justice Brennan and was the Supreme Court correspondent for the Wall Street Journal. Please welcome our panel to today's discussion. I mentioned in the opening that this has been an eventful time for Supreme Court watchers, and looks like it could be again. And so before we get into some of the specific cases that you're prepared to speak to us about today, I wanted to ask each of you to briefly just give us your sort of overview of where we're headed and how it relates to the previous terms where we've seen what have been referred to as blockbuster cases covering things like gay marriage and affirmative action and affordable health care and a range of very important issues. And so in the order of introduction, Renee, if you would give us your sort of capsule preview of what we can expect. Is it more of the same? Are we headed to the types of cases that enter the public consciousness and go beyond legal watchers?
Yes, I do think that there will be some more cases like that this term. I think the case about the recess appointments clause will be one of those cases which tries to sort of mediate the power dispute between the Congress, the Senate and the President over appointments power. I think that some of the abortion is perhaps in some form is going to be on the docket this year again. So I think there will be cases that will have some recognition among the general public.
David.
Yeah, I think that's right. I think we've seen from the court over the last several years, and really going back farther than that, an absolute willingness, if not eagerness, to sort of inject themselves into what might otherwise, be perceived as fairly controversial and or political issues. That doesn't seem to deter them at all. When they have issues they want to resolve, they
In the
get
history
right
of
in.
the court, is that usual or unusual?
I think it varies. I guess what I would say is I think we have a court today that is perhaps unusually comfortable in the exercise of its authority and its power. If you go back, say, to the Burger Court, and you read some of the opinions when they would from time to time strike down an act of Congress, you inevitably would see a page or two of what I would refer to as sort of judicial hand-wringing about, boy, we really hate to have to do this, and we know we're sort of at our lowest ebb here. We're counter-majoritarian, and we're really sorry, but we have to strike down this act of Congress. It's really hard to find decisions that have that kind of language about the exercise of judicial power these days. They're very comfortable with the exercise of it. I don't know that's necessarily a bad thing, but I do think it's a difference.
Yeah. David Savage.
Well, this is a case where there's a lot of big issues before the court, and they could decide them narrowly or in a small way. A couple of years ago, there were huge cases on the Health Care Act and gay marriage that sort of focused everybody's attention. But this one has religion, civil rights, abortion regulation, abortion picketing. There's a whole bunch of these campaign finance and contributions. There's a whole bunch of cases where if the 5 conservative justices really want to change the law, and that's the way the cases are being pitched, they could be a real big term. But it's very hard to know whether they're going to decide them narrowly or do something really big.
Mm-hmm. Mm-hmm. Steve.
I guess I agree with everybody that has spoken already. I think it's potentially a very big term. I don't think the court is at its best when it is right smack in the middle of the headlines of the day, but I think this court finds it inevitable and unavoidable, and I think that's where we're going to be. I mean, the case we're not going to talk much about involving the chemical weapons treaty, it's an obscure issue and an obscure case, but it's the same treaty that we were talking about in Syria and elsewhere, and the court's going to find itself in the middle of that issue in a somewhat obscure way, but right in the middle of the news.
The point that David started talking about, David Salmons, is this more a sign of this court or a sign of the times? In other words, is it just a luck of the draw that these cases are coming up at this time and this happens to be the court in place, or does this say something about the nature of this Roberts Court?
I think it's both. I think there are more, we're in a period, not the first time, but where many, many issues are coming to the court to be resolved. There are some of those issues where the court probably could have sidestepped but doesn't really want to. I think it's more than willing to step up to the plate.
The other difference is that now we have a lot of organizations on all points of the political spectrum who are looking for cases to try to get issues to the court. And I think that's a unique feature that's been sort of building over the last, decade or so, where these, really searching for the cases to try to get their issue for a decision by the court.
Okay, let me tell you a little bit about the format for the rest of our discussion. What we're going to do is we conferred with our panelists prior to today to talk about their identification of cases or issues or clusters of cases that fit under a certain theme that they wanted to talk about and they think are most important to talk about. And so we're going to do each of those discussions will be led by one of our panelists on a particular topic area, and then we'll have some discussion within that. And then eventually we'll come to you for questions and comments. And first up are cases that we've clustered under the banner of civil rights, and we've asked David Savage to speak about that. David.
Well, I'm going to talk about two. There's an affirmative action case in mid-October, early in the term. You remember last year we had a case, the traditional affirmative action case, where you have a white student sues and says, I was wrongly denied because the university has an affirmative action program, and I was denied the equal protection of the laws. That was a case from Texas. And the court basically sent that back, gave her sort of a small win. This year we have the sort of opposite situation where the state of Michigan, the voters voted a state proposition that basically ended affirmative action at the University of Michigan, and a group of minority students sued, arguing that this was an inappropriate change in the law, and they won. So this is the sort of affirmative action from the other way. This to me looks like a case where the Supreme Court, particularly the conservative justices, are going to be inclined to reverse the lower court and uphold this proposition. And I'll tell you that this is one of these cases where I think if you could just read the law and then tell me what your answer is. Here's what the proposition says. The University of Michigan, Michigan State, Wayne State, and any other public college shall not discriminate against or grant preferential treatment to any individual or group on the basis of race. And then it was challenged on the grounds that it denies that it violates the 14th Amendment, which says no state shall deny to any person the equal protection of the laws. Now, my strong view is that the likelihood is that the Supreme Court's going to say that proposition doesn't violate the equal protection of the laws. It simply says you may not consider race, which is a sort of a setback for affirmative action, but my guess is that that's how that's going to come out. There's another case involving fair housing and whether policies that have a discriminatory effect on minorities violate the Fair Housing Act of 1968. Remember, this is the law that was passed immediately after Martin Luther King was assassinated. You know, the idea that it's that law, and the Supreme Court has never decided this question. It's always been the case that if you have intentional discrimination, somebody refuses to rent an apartment to minorities, that violates the law. But there's a whole series of cases that involve the question of whether there's some sort of mortgage lending policy or city housing policy that has a discriminatory effect. Most of the lower courts have said that's okay. The Supreme Court now has twice taken this question up. The first case washed out. Tom Perez managed to settle it before the Supreme Court could decide on it. But anyway, that's a big question of whether policies that have a discriminatory effect on minorities are covered by the Fair Housing Act. And you would think, based on going into it, the likelihood is they're going to say no.
David, the first case, is Elena Kagan, has she recused herself from
She
that
is,
case?
and I can't tell you why.
What's the impact? You can't, okay.
Well, I mean, I assume she had something to do with it when, as a Solicitor General. I don't think her being out affects at all the outcome. It'll be a 5-4 reversal or a 5-3 reversal. So I don't think in this case her being out has any effect on the likely outcome. And she has said that if she had any involvement in a case or issue when she was at the Solicitor General's office, she'll recuse when it gets to the Supreme Court. So I assume that's the reason.
Okay, this is an opportunity now for other panelists to weigh in, either if you want to add anything to what David has shared or if you'd like to ask him a question.
Well, what do you think the impact of the Romer against Evans case will be on the court's decision in that case about a similar kind of proposition in Colorado, where the court actually went the other way? It was I think, a 5-4 decision, and an opinion by Justice Kennedy, where the court concluded that there was what's sort of in the shorthand is a phrase is the political process violation, right. That by enshrining in the Constitution a prohibition on affirmative action, it creates a barrier to some groups in the political process, because they have to do more. They have to overturn a constitutional amendment in order to enact a law that protects their interests in a more elaborate way somehow.
You asked the single hardest question for the conservative members of the court, because that's the argument here, as she said, is that by putting this in the Constitution, you've said to minority students, you can't get any sort of affirmative action program where athletes can get a preference or alumni kids can get a preference. The university officials can't do anything for you. The regents can't. You've changed the political structure. And as Renee said, in a gay rights case in the 90s, Justice Kennedy essentially used that rationale for knocking down a Colorado amendment that said no discrimination laws in this state involving sexual orientation. And that threw out laws in Boulder and Aspen and a lot of other towns. And his rationale was, you've changed the political process. I think they will find a way to work around it and say something like, that was about discrimination against gays and lesbians. Michigan doesn't allow or encourage discrimination against minorities. They're just not going to allow affirmative action programs. And I think they'll have a few paragraphs in the opinion to try to deal with just that question.
Yeah, I assume that's right. I assume the argument they would make would be something along the lines of, here the statute is neutral. It doesn't prefer one group over the other. It just says everyone shall be treated equally. Whereas the law you had in Romer sort of singled out certain rights that could not be added by local municipalities, but it could only be added. Gay rights could only be added at the constitutional level. This is arguably a little more neutral than that statute, and whether that's enough to make a difference or not, I guess remains to be seen. I've always viewed the Romer case, for what it's worth, as in the same way that the DOMA case cases from last term worked out. What's really going on is sort of a legislative intent analysis, that the court, and especially Justice Kennedy in both of those cases, has an acute sense of smell for what he perceives to be discrimination against certain groups, and in particular gays and lesbians. And I think that's what was driving, I think, in Romer. It's what drove his analysis in the DOMA cases, whether or not he will view this provision as sort of being motivated by some kind of animus, as opposed to a desire for equality, will, I think, dictate, which hat he puts on. Is he sort of on the moral high ground of I have to stop discrimination, or is he, perceiving some unfairness to a particular group?
Well, the other thing is how do you define equality? Does equality mean treating everyone the same, or are there, other more subtle ways of viewing how one achieves equality?
I mean, the distinguishing feature to me here, I think, for Kennedy is Grutter, in a sense, is going to be the undoing of its own affirmative action in Michigan, because to the extent that Grutter said we're not remedying past discrimination, we're promoting future diversity, Kennedy can distinguish and say Romer was about prohibiting gays from going to court even to remedy discrimination, but in the affirmative action sense, we're not remedying discrimination, we're promoting diversity, which is a different value, and so I think it's easier for him to go along with the proposition that prohibits affirmative action, or at least I think he could convince himself of that.
Did you want to add something else, David?
I was just going to say, in the fair housing case that I brought up, one of the interesting things if you cover the court and you're a non-lawyer like me is the things that are discriminations that are okay and the discriminations that are not okay. This case involves a situation where a little town in New Jersey had a part of the town where about 80 or 90% of the people were very poor, and they had houses that were worth $30,000 or $40,000. The other part of the town had houses that were worth $200,000 or $300,000. The town council got together and said, basically, let's get rid of those poor people's houses. Everybody sort of agreed that, oh, that's fine. You can do that. You can drive the poor people. We'll buy up their houses, knock them down, and say, by the way, if you want to buy in, it'll be $250,000, which they couldn't do. all that's fine. You can't even go to court to challenge it. But a substantial number of those persons were black or Hispanic, about 75%. And so there may be a way to stop this because of the racial discriminatory effect. But I just reading it, I read cases like that, and I think, what kind of a system would say it's okay to discriminate against poor people and drive them out of town? That's fine. That's not affected by federal law at all.
Before we move on to the next discussion area, David, I want to look back in the civil rights category to last term and the big decision on the Voting Rights Act. With time to reflect on that and look back, is this essentially, as some see it, the court dismantling the Voting Rights Act, or is this a challenge to Congress to make legislative moves that are potentially more in touch with the times?
Well, you could call it both. I mean, they know Congress is not going to be able to pass a new law that puts the southern states under the special scrutiny. My impression was a good Congress could, and so you can all stop there and pay no further attention, but a good Congress could actually get together and pass a national voter rights or voting protection law that tried to make it all across the country, that have a situation where registered voters are not prohibited from voting by new voter ID laws that sound good, but if you live 100 miles away from the nearest DMV and you don't drive because you're 85 years old, it's not so easy to go and get that. So you could actually pass, Congress could, and I think there's a small chance Obama's going to push this again, come up with some sort of national voter ID law to protect voting rights, but I don't think they'll bring back anything like the old system where the South is under this sort of special scrutiny.
Yeah, okay. The next area we're going to take a look at are First Amendment cases, and we've asked Steve Wormeal to talk about those.
So I have a Ted Cruz amount of material to present and about 5 minutes to do it.
Starts with green eggs.
Does it include green eggs and ham? Yeah, I was going to ask that.
I want to mention 3 cases, and I'll do one at a little more length and then maybe just briefly mention the other 2. A case called Town of Greece versus Galloway has nothing to do with the country of Greece. This town of Greece is near Rochester, New York. And since 1999, the town council has started their council meetings with a prayer. Most of those prayers, all of them from 1999 to 2007, were delivered by a Christian clergyman, different Christian clergyman, but nothing but Christian. The town adamantly says, and the record seems to support, that they don't turn anybody down who wants to deliver the prayer. If non-Christians want to deliver the prayer, that's fine. But none did from 1999 to 2007. 2 local residents complained. In 2008, the town had a few non-Christian prayers at the start of the council meetings, one by a Wiccan priestess, one by a Baha'i leader, and then a local Jewish man decided to deliver. He was not a rabbi, but he decided to deliver the prayer on a couple of occasions. So on those 4 occasions, they had non-Christian prayers. But again, the town stresses, we have an open policy. We want the prayer. Anybody can deliver the prayer. We don't turn anybody away. We don't screen the content of the prayer. And so we're not favoring anybody. The 2 people who challenged the policy basically say this violates the Establishment Clause of the First Amendment because they essentially made 2 arguments. One was that the town is favoring Christianity and in essence establishing Christianity as the favored religion. But 2, even if they weren't favoring Christianity, that the content of the prayers is very religious and sectarian in nature, and so the existence of the prayer itself violates the Establishment Clause. This comes to the Supreme Court from the Second Circuit, and the Second Circuit basically bought the favoring Christianity argument. The Second Circuit rejected the idea that merely having the prayer at the start of council meetings was itself a violation of the Establishment Clause. and said rather that because all of the prayers or most of the prayers had been delivered by Christian clergy, that this seemed to be favoring Christianity and that a town can't do that. The Supreme Court faces a kind of crossroads of precedents here. In 1983, the Supreme Court upheld a prayer at the start of the legislative day in the Nebraska legislature, and upheld it because of long-standing history and tradition. In Nebraska, the clergy who had delivered the prayer every day was paid by the legislature, same person all the time, same faith. But the court said, going back to the first Congress, we've had prayer to solemnize the beginning of the legislative session. And this is in that tradition in Nebraska. So that's one of the arguments here, is that the court ought to uphold this tradition because we have 200 plus years of history of legislative prayer. For the Second Circuit, the flip side was a line of Supreme Court decisions that say, yeah, but you can't favor particular religions. Having legislative prayer doesn't excuse the fact that you can't have government picking and choosing a particular religion and favoring that religion. And there are a number of cases that play into that. So the court kind of has to figure out which precedent is going to take the lead and how to decide this. And then there's a wild card, which is none of the above. There are, as you know, probably more Supreme Court tests for the Establishment Clause than teams vying for the wild card spots in the Major League Baseball. And maybe the leading one of relevance here is Justice Anthony Kennedy, who has said that when something coerces individuals, when a religious practice by government coerces individuals, that violates the Establishment Clause. So one question here is, when you go to the town council because you have business to present to the town, and you have to listen to or participate in the prayer that perhaps isn't your faith, is that coercive, and does that violate the Establishment Clause? And both sides are arguing that it does or it doesn't as to coercion as well. So that's one case that I think will be very important. There are lots of legislators, lots of counties, lots of states that have filed amicus briefs and a lot of interest in it. Last point on that, and of particular note, the Obama administration has actually filed a friend of the court brief on the side of the town, saying that this practice did not violate the Establishment Clause, that the established law is simply, as long as the prayer is not proselytizing a particular religion, nor denigrating any particular religion, the courts should stay out of the business of screening the prayers and examining the content. And the Obama administration, the Justice Department, says that's not happening in this case, so leave it alone. It's perfectly constitutional. The two others I want to mention, how am I doing on time?
Go right ahead. Go right ahead. You're good.
McCutcheon versus the Federal Election Commission. This is the extremely important but maybe somewhat forgotten part of the federal campaign finance scheme. This is not about individual spending limits on campaigns, and it's not about donation limits. This is about the cumulative limits. Most people probably don't even know they exist unless you're in the big giving category. Going all the way back to the first campaign finance law, Congress imposed a 2-year cumulative cap on what an individual can give to federal campaigns, presidential or congressional, in different categories. The current cap is $74,000 in a 2-year cycle to non-candidate committees, including to local political parties, and $48,000 roughly to candidate committees in a 2-year cycle. This is separate from how much an individual can give to an individual candidate in a particular election. You can give $2,500 to a candidate in the primary, You can give $2,500 to a candidate in the general election. You can do that as often as you want, as long as it doesn't exceed the $48,000 in a 2-year cycle, or to non-candidate committees, $74,000 in a 2-year cycle. A special three-judge court in D.C. upheld these restrictions. They're being challenged by an Alabama Republican activist and the Republican National Committee. The activist says he wants to give more. The Republican National Committee, not surprisingly, says we'd be happy to have it. And they say that this doesn't really raise the same First Amendment issues that other parts of the campaign finance scheme raise. This is not about the corrupting influence of donations, and that was never the rationale for this provision, they argue. The rationale for this provision was what they call the evasion rationale, that you can't evade the other campaign donation limits by making cumulative donations that exceed the individual limits, but it was never argued that these particular amounts were based on some notion of the corrupting effect of campaign donations the way the individual limits were, and therefore the First Amendment analysis ought to be different. Last one, in 10 seconds or less, the Supreme Court on at least, I think, 3 or 4 different occasions has considered so-called buffer zone laws outside abortion clinics. When can anti-abortion protesters protest outside a clinic? How close to the clinic can they get? How close to individuals going to the clinic can they get? Massachusetts has a new version of this law passed in 2007 that says you have to stay 35 feet away from the clinic if you're going to protest or try to counsel individuals going to the clinic, except that employees of the clinic are allowed to be in the buffer zone. Anti-abortion protesters say this violates their First Amendment rights. A, it applies only to abortion clinics and not other facilities. They say that's content discrimination. B, by allowing the clinic employees inside the 35-foot zone, it's viewpoint discrimination because they can favor abortion, but the anti-abortion protesters can't oppose abortion inside the 35 feet. And then they say it does not leave open adequate alternative means for them to get their message across, which is a key part of the First Amendment analysis. They want to do face-to-face counseling to the people going to seek abortions, and you can't do that if you have to stay 35 feet away. That's the essence of their
Take
argument.
the pamphlet, but that's all.
A megaphone, perhaps. Go ahead, David. Yeah, I see you.
I was going to say, I wrote about the campaign finance case last week, and I thought this is a good news case, but for a very small group of people. Yeah, I don't know your financial situation, but for those who feel that they're handcuffed by the $123,000 limit on giving to parties and candidates, this means if they win, you'll be able to give $3.6 million in the next 2 years.
Show of hands, who's happy to hear that?
So
Because I want to
for
follow
that
this
small group
person
of
out
people,
here.
this is a case to watch because you may be freed from that $123,000 limit that you now labor under.
Will this case have the potential to resonate in a polarizing way, the way that Citizens United did, or are the technicalities that were described by Steve that limit sort of how many people this affects? Does that change the equation, or will this be seen as just more of the
This is a
same?
stepping stone case. I mean, it would be a big deal if the court were to throw out all the contribution limits, right?
Yeah.
And say that I can give $1 million to a candidate for Congress or whatever. That would be a big deal. This is a stepping stone case to get there because they're going to say the contribution limits overall, we're going to lift them, but we're not going to. So I don't think this will have the Citizens United but it's a step in
But there's
that
an
direction.
asterisk only in the sense that the underlying the arguments, they're essentially saying if you can't see the difference between cumulative limits and the individual donation limits, then overrule Buckley. That's not their main argument, and I don't think it's likely the court will do that, but it is there. There is that kind of, fourth argument. If you can't figure this out, then it's time to do away with all the limits, period.
David, Renee, anything you want to add to the First Amendment portion of our discussion before we move to the next segment?
Well, I think on the buffer zone case, and I live in Massachusetts, and I should also disclose that I'm a member of the Planned Parenthood Board of Massachusetts, but there is a competing constitutional right here that's different from some other First Amendment free speech things, that the people trying to enter abortion clinics, some of them arguably are trying to exercise another right, which is to have access to reproductive health care services, including abortion, without unnecessary impediment
Right.
and interference from other people in the exercise of that right. So it's a slightly different First Amendment kind of issue, and I think that there are rights on both sides. That
Well,
make
and the
it
states that
complex.
have those laws justify the laws on the need to protect the right of access to
Right.
the clinics on the part of women seeking abortions.
You know, some of the justices will be skeptical of this buffer zone notion, but the amusing thing, of course, is that they have a buffer zone around the Supreme Court that they're very willing to enforce, that you can't, picket or protest up on the steps of the court. So they understand the concept of buffer zones. It's just, it's not going to play so well in this case.
The only thing I'd add about the First Amendment is when this court wants to, I think it is as protective of the First Amendment as any court we've seen. And I think, again, Justice Kennedy, not surprisingly, the swing vote, when he decides that he has to vindicate some important First Amendment issue, he throws himself into that task. And I think, it'll be interesting to see how these come out, but I would not necessarily bet against the First Amendment arguments in any of these cases. I think they have a lot of resonance.
The big precedent is from 2000, and it's a case from Colorado in which the court upheld a buffer zone. The two members of the majority who upheld the buffer zone that are still remaining on the court are Ginsburg and Breyer. The three dissenters in that case that wanted to strike down the buffer zone were Thomas, Kennedy, and Scalia. So if you want to do the math and try to guess where you're going to put Roberts and Alito in that chart, you might get a sense of how that case might come out.
Yeah, we'll talk a little bit more about that later, how predictable or not this court might be. David Sammons is up next, and he's going to talk to us under the banner of what we're calling business cases. And essentially, someone both praising the court and criticizing the court has said that the Roberts Court is certainly good for the Chamber of Commerce.
The Chamber of Commerce has done very well so far under the Roberts Court. I think that is certainly true. So I'm going to focus on business cases. That's kind of a loose category. Perhaps you could reasonably characterize it as cases that get a lot less attention than same-sex marriage and affirmative action. In actuality, the court's business cases from last term, I think, are quite important and have attracted a fair bit of attention in their own right. I'm going to focus mostly on last term. There's several business cases for this term. It's hard to tell yet, with some of these business cases, whether you have a blockbuster on your hands or not. I think most of the cases for this coming term look relatively like small ball to me, but we'll see how things develop. But inevitably, it's a significant part of the court's docket. This last term, there were 33 or so, depending on how you count, business-related cases at the court. That's just under half of the court's total docket. Those cases covered a wide range of issues, including class actions, arbitration, intellectual property, employment, transnational torts, and the takings clause. And just as with the court's more political cases, and as we've already talked about, the Roberts Court showed no bashfulness about entering into controversial or contested issues and rendered a number of very significant decisions last term. Let me start with just some general statistics and observations about the term. Over half of the business cases, 17 out of 33, were decided by a unanimous court. That's slightly higher than the percentage of unanimous cases in other contexts, but I'm not sure it's statistically significant. Only 10 of the business cases, or less than a third, from last term were decided by a vote of 5-4 or 5-3. Of those 10, what we'll call closely divided business cases, 9 were decided by what you could characterize as an ideological or conservative versus liberal voting pattern. Of those 9 ideological business cases, Justice Kennedy voted with the conservative bloc to make the majority in 7 cases, and with the liberal bloc in 2 cases. So in every one of those 5-vote majority business cases last term, it was good to be Justice Kennedy. You were in the majority. Some have noted that the Solicitor General's office, which normally participates in about 3/4 of the Supreme Court's cases, and typically wins well over 2/3 of the cases in which they participate, either as a party or as an amicus, have struggled at times before the Roberts Court, especially the last term or two. In business cases last term, the record was not the SG's best. The SG's office prevailed in only 14 of the 27 cases it participated in. That includes both amicus and party. It had a slightly worse record outside of the business context. Overall, last term, the SG's office prevailed in roughly about 45% of its cases. I would just add, I know many people in the SG's office, I'm an alum of that office myself, that is not a reflection on the quality of the lawyering that comes out of the SG's office, but I do think it reflects perhaps the differences between where the administration is and where the court is on some of these issues. To provide some contrast, although it participated in far fewer cases than the SG, the U.S. Chamber of Commerce enjoyed great success last term in business cases, prevailing in 14 of the 18 cases in which it participated as an amicus, or a 78% success rate. Let me move now to some individual cases from last term, and I'll break them up into categories to make the discussion go a little quicker. Since these are not the most exciting necessarily to all of you, unless you're really kind of the Civ Pro mavens of law school, I'll try to move quickly. First, dealing with class actions. The court has been very active lately in this area. This past term alone, the court had 6 decisions that dealt in some way or another with the issue of class actions. That's pretty remarkable. Justice Scalia in particular has been very influential in the court's class action jurisprudence. He had a statement for the court this term in a case called American Express versus Italian Colors Restaurant, which is sort of more of an arbitration case than a pure class action case, but it implicates both. The Italian Colors Court held that the Federal Arbitration Act does not permit courts to invalidate a contractual waiver of class arbitration on the ground that the plaintiff's costs of individually arbitrating their federal statutory claims would invariably exceed the potential recovery, and so as a practical matter would make remedies useless. Writing for a 5-justice majority, Justice Scalia stated, quote, Rule 23 imposes stringent requirements for certification that in practice exclude most claims. That's very blunt and very straightforward. They think most class action claims have to lose at the class certification stage. That view was challenged vigorously by the more liberal justices of the court, especially Justice Kagan, who accused the majority of being, quote, bent on diminishing the usefulness of Rule 23. I guess there are worse things you could be accused of doing, but that's still not good, and dismantling the class action device. Just how stringent are Rule 23's requirements and how few cases can actually satisfy them will undoubtedly occupy the court for some time. There's at least one Class Action Fairness Act case up before the court this term, and I wouldn't be surprised to see more class action related cases, if not this term, than in the coming terms. The Amgen case from this term illustrates just how tough it can be for class action plaintiffs. Although the court in that case in a 6-3 decision upheld the Ninth Circuit's decision actually certifying a class and limiting certain evidence that the defense can put in at the certification stage, Justice Alito filed a separate concurring opinion calling into question the whole fraud on the market theory that presumes reliance by all stock purchasers in an efficient market. If that presumption gets lost in future decisions, you could eliminate most, if not, well, I guess not all, but certainly most of the securities class actions that exist today. That's a potentially very significant issue. The second area I would just cover quickly is deals with arbitration. The court seems to have at least one or more arbitration cases every term. There's one already for next term. In this term, the focus was on the arbitrability of the class-wide arbitration and when it's available. And the court was in some ways of two minds. In the Oxford Health Plans case, the court upheld class-wide arbitration where an arbitrator looked at the underlying contract that on its face didn't particularly address the availability of class-wide relief, and at best was ambiguous on the question. But the arbitrator resolved that based on an analysis of the intent of the parties and concluded that class-wide arbitration was available. The Supreme Court unanimously accepted that, did not reject it, and basically left that to a question for arbitrators. In the Italian Colors case I mentioned before, the court rejected what had been known as the effective vindication rule, which had said in the lower courts that if essentially you could only bring claims through a class action manner in order, because of the low amount of money that's involved, you must provide that as an available form of relief. And the court would have nothing of it, and in a tight 5-justice majority said the sole issue is one of the party's intent. In the area of intellectual property this term, there was some very significant decisions dealing with DNA and whether naturally occurring DNA segments are patentable. The court said they are not, but addressed a number of fairly cutting-edge issues involving synthetic DNA and other types of patent claims in this context that will still provide, I think, a fair amount of room for patentability. There was a first sale doctrine case involving the Copyright Act. I can see everyone's eyes glazing over, so I'm going to wrap this up very quickly, which had to do with whether the manufacturers of copyrighted products that are sold first overseas could control the downstream distribution of those products when they're brought into the United States. That was a very important business issue, and you had manufacturers and retailers and others closely divided on that. Finally, let me just say a few words about next term. As I said, there's at least one arbitration case, keeping with tradition. There's important Fair Housing Act case, which we already spoke about. There's issues involving the Securities Litigation Uniform Standards Act, or affectionately known as SLUSA, and how much state law is preempted by it. There's a fun case about, I'm a law geek, a fun case about the due process rights of foreign corporations and when they can, a court can exercise personal jurisdiction over a foreign corporation based on the activities of a subsidiary. Rest assured that even though they're fairly slim pickings right now, by this time next year we will have something to talk about in terms of the Supreme Court's business cases.
You know, there's only so much we can cover in a 90-minute session, but you talked about the DNA rulings, and one of the things that I have on my notes, but we probably won't get to, are these 2 cert petitions on searching cell phones. But it brings up a broader theme that I just think is worth stating about a lot of these rulings the court's making, like in the DNA case. You're talking about science that's changing so rapidly before the circumstances of the case are heard and before rulings are issued, we're into something completely different. And so that's going to create increasing challenges, not just for the court, but for legislators, for all of us.
Well, so it was interesting in the Myriad Genetics case because a great deal of the opinion is devoted to describing the underlying science at issue. And Justice Scalia, in a concurrence, took issue with that and said, you know, really he wasn't signing on to the description of the science because that's not what the court does. Mm-hmm. And so it's very interesting because on the one hand, they have to understand the science in order to be able to make a meaningful resolution of the case. But on the other hand, it's the one time I think I agree with Justice Scalia that he's absolutely right. They're not scientists, and why should we rely on the court's description of how these DNA mechanisms operate?
I think it's a great point, and I'll tell you that as an advocate, it is very common for the justices to start asking questions at oral argument about some of those kinds of issues. Yeah. They're interesting. They may have some relevance to the analysis that the justice is thinking about, but there's nothing in the record on it half the time. And you have to be prepared to give an answer, but the truth of the matter is that there's no judicial record on which to rely on some of those issues. And undoubtedly that was the case here as well. And it creates very difficult problems for the court when you start getting into those issues.
David Savage, you were going to say something?
Yeah, let me put in another sort of good word for Justice Scalia on the, you're absolutely right to say they're very skeptical of class action lawsuits, but I think this is, from their point of view, a pretty well-founded skepticism. They see a whole lot of class action lawsuits that come up to them, and as they would say it, they look like entrepreneurial lawsuits. They look like lawsuits where the lawyers have ginned up a lawsuit and they've found a few plaintiffs, very small claims, And if the case goes forward, the lawyers make a lot of money. There was a case a couple years ago from California called Concepcion, AT&T, and the claim was this couple bought got a free cell phone for some offer, but they were charged a sales tax. So that was their gripe. They got the free cell phone, but there was they had to pay the sales tax. So they wanted to, some class of 1 million people, got these free cell phones, but we had to, and that's the kind of thing that I would think that, for God's sake, if we allow this to go forward, they'll then go back to AT&T and get a couple $1 million settlement. The lawyers will get most of the money, and what are you going to get? Your complaint is I had to pay a $20. So they look like ginned up lawsuits that are, sort of legal business. So I think they come to the court they're very skeptical. And for example, in that case, you could go to arbitration and you could win $7,500 for AT&T for giving you that deceptive offer. If I was that person, $7,500 is not bad for having to pay $20 for sales tax. So I think part of the problem with the class action lawsuits is that justices don't really think these are much about real justice for real people. They're lawyers' cases.
But the problem
Okay.
is, I'm sorry.
No,
but
go ahead.
when those generalizations about that kind of case, which I agree with you are very suspect, get applied and they say the employment discrimination context against a large employer or something
No,
like
you're
that, because that's when it starts to get
Like the
worrisome.
Walmart.
The Walmart.
Fortunately,
yes.
we need to
Sorry.
move on. No, there's so much fertile ground here. It's
Told you that
difficult.
business cases were interesting.
See, we're proving you right.
He just needed help.
You don't have to be a law geek. Renee Landers is up next, and Renee doesn't have a specific grouping of cases as much as we've asked her to talk about a couple things, recess appointments, and certainly a case that has huge implications potentially for presidential powers and separation of powers, and then also some update on Obamacare or Affordable Care Act.
That's right. So, and I guess the unifying theme of these two cases, I was trying to think about that today conceptually.
I didn't come up with one, obviously.
Well, and one is that now these cases really do involve trying to use the legal system to rectify problems with the political process and in the political system, where in the recess appointments case, where the Senate, the president nominates people, the Senate says they don't like them, the president won't nominate people that disagree with his policies, and so the Senate doesn't confirm them, and there's a standoff, and meanwhile the government agencies don't have people who can run them and who can make decisions. And then the second set of cases, the challenges to some of the implementation issues involved that we're now getting into with the Affordable Care Act, again, it's, if we thought in 2012 when the Supreme Court decided the National Federation of Independent Business case that the legal arguments were over, there are many more chapters, I think, to be written in this dispute, because the people who don't like the law will continue to bring these challenges, and there are, there are some meaty legal issues there. So on the recess appointments case, the background is that in 2010, the Supreme Court decided a case called New Process Steel against NLRB, where the court said that that at all times that the NLRB statute required that the National Labor Relations Board's powers had to be vested in a group of at least 3 members. And at the time, a 3-member group of the NLRB had delegated to a committee of 2 that was then making decisions about, rendering decisions in NLRB adjudications. And so that was one kind of wrinkle on the appointment power of the president, saying that there had to be a quorum of 3 people at all times. And then more recently, in just this year, the D.C. Circuit decided a case called Noel Canning, where the issue was when could the president use the recess appointments power in Article 2, Section 2 to fill vacancies. Article 2, Section 2 says that the president may fill up all vacancies that may happen during the recess of the Senate. And there was an unfair labor action brought against Noel Canning, which is a company. On the merits, the NLRB decided that the company had committed an unfair labor practice. The NLRB agreed. The D.C. Circuit agreed, but then considered Noel Canning's argument made for the first time, not before the NLRB, that that two of the people who were serving on the NLRB at the time had been appointed in an intra-session recess, a recess taken during a session of the Senate, and furthermore that the appointments had been for positions where the vacancies had arisen before the recess. So the argument is that the argument is that the D.C. Circuit accepted was that the president may only use this recess appointment power during an inter-session recess between two different sessions of the Senate, and that and furthermore that the president may only fill vacancies that occur during that recess. So the combination of the quorum requirement and this interpretation of Article 2, Section 2, really meant it was impossible for the NLRB, at least in the D.C. Circuit, to conduct any business. Both cases put at risk literally hundreds of decisions made by the NLRB during this time in adjudications. I won't go through the specific numbers because your eyes will glaze over, but hundreds of decisions, and furthermore, hundreds of administrative kinds of appointments of regional counsel, regional directors, and offices in the NLRB all around the country. Another agency that was affected by this decision was the Consumer Financial Protection Bureau, because the president, on the same day that he appointed the members of the NLRB in this exercise of the recess appointment power, he appointed the director of the Consumer Financial Protection Bureau that administers the Dodd-Frank Act. This was the job that Elizabeth Warren thought she was going to get but didn't get because the Senate wouldn't confirm her. So, so it put at risk a lot of the rulemakings that the Consumer Financial Protection Bureau had undertaken in an effort to get the Dodd-Frank Act and other statutes up and running. So the government decided to actually get a real decision about this from the Supreme Court, and that case is scheduled for argument this fall. So when you look at the textual arguments about what do the words mean, there's been a lot of reference in the briefs to dictionaries written at the time of the Constitution. What the definite article "the recess" means, as opposed to if the Constitution had used a recess of the Senate. There are debatable issues on both sides about where the words get you and what the historical argument is. And certainly the practice in recent years has been that presidents have increasingly, some more than others, use this recess appointments power. The other issue is what should the court moderate these disputes between the political branches? Is that the right role for the courts, or is this really the classic case of a political question where the court should take a pass and say, there are mechanisms. You can work this out, which of course subsequently the president and the Senate seem to have done, at least for these two agencies. The NLRB since last month now has a full complement of members, and the director of the Consumer Financial Protection Bureau has been confirmed also by the Senate, and at the end of August, the agency published a notice in the Federal Register where the director says that he believes that all the actions he took during the period when he served as a recess appointee were legally authorized and entirely proper, but to avoid any possible uncertainty, he's affirming and ratifying all of them now that he is a Senate-confirmed appointee. So this will be really interesting how the court deals with this. And then the final question in these cases is, what is the remedy, right? So the history of these things is, if you look back at the history of all of these appointments powers disputes, starting with Buckley against Valeo, the connection to the campaign finance issue, is that the court has been reluctant to upset the decisions that were taken by the agencies, even though the appointments of the officials are subsequently invalidated by the court. Realizing that it's incredibly disruptive to the operation of the agencies and to people's expectations about the legitimacy of government actions. Frequently, the requirement is imposed prospectively. So even if the court were to decide the case I would think that they probably will, in a sense, not undermine all the decisions that have gone before. So Noel Canning may win the battle about the interpretation of the Constitution, but maybe not win its case, right, where the NLRB decided against it. And then finally, on the future of the ACA, I'll be brief about this, and maybe we can talk about it more in the discussion. There are sort of two big categories of cases that are percolating up through the lower federal courts. One are these challenges to the requirement that health insurance plans that must cover under the Affordable Care Act, preventive health services must cover FDA-approved methods of contraception. A lot of religious-based organizations and people who say that they have strong religious views opposing contraception or abortion, because some of them they view as as operating like an abortion procedure, have raised some First Amendment challenges to this requirement, and also asserted rights under the Religious Freedom Restoration Act. And we can get into what the courts would have to consider and are considering in looking at those challenges. And then the second big category that's emerged more recently, and actually I should say that there are about 72 cases that have been brought challenging the contraceptive provision with more than 200 plaintiffs. And then the second category of cases are this is when any big statute is drafted, there are glitches and mistakes, things that don't work well together. I mean, I think they're glitches or mistakes, but other people have a different interpretation. The statute, the Affordable Care Act, authorizes the creation of exchanges. It authorizes for operating insurance markets, state exchanges, federal exchanges, partnership exchanges between the federal government and the states, and a fourth category of regional exchanges, where compact exchanges, where states can band together and operate exchanges. In the more than 30 states that have refused to set up state exchanges or to do some kind of compact exchange, the federal government will operate these exchanges. The tax subsidy provision for the exchanges only authorizes this, by its language, the tax subsidy for state-operated exchanges, and does not include the list of other forms of exchanges. The IRS has issued an interpretive regulation saying that the subsidies can be used on these other exchanges, but at least two states, Oklahoma, and blanking right now at this moment on the other one, have challenged that, saying that the statute doesn't authorize the use of the tax subsidies on federal exchanges, therefore the employer mandate can't operate, and therefore their citizens will be exempt from having to have insurance under the Affordable Care Act.
Okay, thank you. Well, we're going to come to your questions and comments in just a moment. Before we do that, I want to ask two very big questions that, and ask you to give brief answers to those that provide some more context for understanding this court and this moment in history. And one is about these 5-4 decisions, and bear with me while I go through another couple of numbers. David Salmons shared some numbers on this court, and these are from SCOTUS blog. Last term, 30% of decisions were 5-4, and the average in recent years has been 22%. You mentioned the Solicitor General's struggles in the area of business, but also overall the Solicitor General wins about 70% of cases. Last term it was 39%. But then, somewhat contradicting that, there were 49% of the decisions that were unanimous last term, and the average in recent years in that regard has been 43%. So that's the one outlier statistic that maybe points to something different. But a quick comment from each of you on where we are, what the meaning of these 5-4 decisions are, if they're a good thing for the court and the country. Anything you would add to provide some greater understanding of these numbers?
Well, one comment I would make is that it indicates that the court is less deferential to the positions taken by the government's official spokesperson in these litigation matters, that they're less deferential to the interpretations of statutes or whatever that the Solicitor General is offering for them.
Okay. David Salmons?
The court's always going to have significant 5-4 decisions. It's just the nature of it. I'm sure that if you asked the justices, they would all wish there were more unanimity, but there's just not going to be. you know, I do think that the court is comfortable with the fact that there are lots of significant questions in our society that are going to get resolved by five judges. They're okay with that. Sometimes it goes their way, sometimes it doesn't. But you know, whether you love them or hate them, and you will have plenty of opportunity to do both, given the way the coalition shift around Justice Kennedy in the coming years. We will continue to see a significant number of 5-4 cases in very controversial cases. The court's going to continue to make law. Sometimes they do it in cases where they have to. I think if you take the Affordable Care Act as an example, you had a circuit conflict. This is a very significant piece of legislation. Inevitably, that case was going to the Supreme Court. You take another situation, say the rights of detainees at Guantanamo Bay. No circuit conflict. An area where in some years past, courts might be more deferential to the executive branch. You have both Congress and the executive largely setting up a process that worked for them. The Supreme Court had no hesitation granting review in that case and reversing both political branches and saying that's not good enough. This is a court that's very comfortable in exercising their power.
David Savage.
I too think it's a sort of an inevitable process. I mean, they sit at the top of the pyramid of the federal court system. They take the cases where judges are split, and so it's almost inevitable that they're going to get a number of cases where there's a lot of good judges around the country who are a little bit conservative, came out this way, a lot of judges a little bit liberal, came out this way, and it's going to get to them and they're going to split 5-4. So I think it's inevitably a part of the process. If you say to them, gee, you had a lot of 5-4 decisions, Chief Justice Roberts or whatever say, well, you know, on the all these other cases, but all the areas like bankruptcy and the sort of things that have no ideological divide, you know, they're just sort of plain lawyers and they'll come out 9-0. But if it's a case on religion or campaign finance, the likelihood is it's going to be a close split.
Steve?
I mean, I would just say a 5-4 decision is still a majority opinion of the Supreme Court. What I hope happens less, and I think probably happens less often, is concurring opinions that purport to change the scope or the reasoning of the majority opinion and thereby undermine the 5-4 decision. If you don't have those, then it, you know,
Confuses
5-4
the law
decision
professors.
is a solid decision. Law professors are easily confused.
Let me ask for a show of hands. How many of you believe that the concept of judicial activism is a real thing? It's not. Okay. And how many of you would characterize this court as activist? Well, you're with Ruth Bader Ginsburg, who, you know, she...
There's one more question.
Go ahead.
Only when they issue a decision that you
Well,
disagree
there
with?
you go. There you go.
And ones that
And
you
that
agree
might
with
be
as
at the
well.
there. Now that could be at the heart of
Question's
it.
no fun.
But let me just say, Justice Ginsburg qualified her claim that this is one of the most activist courts of all time by saying, if measured by readiness to overturn legislation. Adam Liptak, one of our frequent panelists on these events, did a piece in the New York Times where he statistically said that wasn't true. And that's what I want to ask you to comment on, the Ginsburg comment, but also on, you may have already done it, David. Is that what judicial activism is, our reaction to a ruling we don't like?
I think the term really is not useful much at all. I think it's largely devoid of content. But I do think that, as I've said, you know, probably too many times, this is a court that they just have no hesitation about what courts in the past considered the counter-majoritarian problem, you know, the fact that they're the most undemocratic of all the branches. That doesn't slow them down in the least. They are unabashed about that. Maybe it's all the consequence of Bush versus Gore and the fact that they were still here notwithstanding. I don't know, but they are just far less concerned about the fact that they're an undemocratic branch than some courts in the past have been. If you take last term, it's a great example. If you look at the Section 5 case and you look at the DOMA case, okay? And in both of those cases, different majorities, you have a majority of the court that has very little regard for what the legislature did in terms of its process, its fact-finding, and you could not have less deference to a legislative institution in either of those cases, and you've got one on the right and one on the left, and they're right there to behold. Regardless of who's winning the day, there's not a lot of deference for Congress. Now, when you're in dissent, you may accuse the other side of being harsh on Congress, but when you have the opportunity to do so to further your cause, they have no problem in
Well,
doing
on
so.
the DOMA ruling, on the dissents, Justice Scalia talked about the court going against the will of the people and democracy, essentially. But a day earlier, he arguably did the same thing on the Voting Rights
That's my
Act.
point. But in the DOMA case is a great example because not only are you going against, what you might say was the majority of the vote, you're accusing the legislature of having a bad motive. There's no way around that. And it was sort of a surreal moment afterwards. You had many of those legislators applauding the result, even though they had voted for it. Now, I guess I understand how times change and everything, but it was kind of a remarkable example of how little regard maybe everybody has for Congress at this point. I don't know.
Well, and another way to measure activism is to think about overturning, long-established precedents. Nothing is ever settled for all time, and so I think the court also is. Some of the justices are less shy about doing that. I think Justice Thomas has made no secret about his disagreement with the recent, last 70-year tradition of the theories of the Commerce Clause. I think that Justice Roberts makes no secret of his disagreement with some of the cases about race and affirmative action, and I think they take the first opportunity to try to change that law that they think is very wrong-headed, and I think that's also a little concerning.
Yeah, I agree with all that. I thought both Justice Ginsburg and Justice Scalia, both of whom went out in the summer and gave speeches about how the court is activist, ought to explain why their activism is good and the other side's activism is bad. Because if they were on TV at the end of June, those of us who go up there and listen to them, you have one day, on a Tuesday, they strike down the Voting Rights Act, the Section 5 on a 5-4 vote. Ruth Ginsburg reads this long dissent saying, this is the Voting Rights Act was decided by Congress. We have no business doing this. The next day, they strike down the Defense of Marriage Act. And Justice Scalia says the same thing, and neither one of them bothers to explain why their view of striking down a statute is a good idea while the other side's is a bad idea.
It's a given. I think we think we once knew what activism meant, and the factors have been mentioned here: deferring to the elected branches, respecting precedent. If those are the measures, this is a very activist court. They don't defer to the other branches. They don't seem to care about precedent, except when they do. But I don't know that label now tells you very much that's useful in a way that perhaps it once did.
All right. Okay, well, we're going to turn to your questions and comments. A couple of rules of the game. Please just identify yourself, tell us who you are, and also please limit yourself to one question, and when you can, direct it to a single panelist. I know that's not always possible, but it's helpful when you can. There's a gentleman in the back of the room there, Eric. He can start off. Yes, sir. Hi.
Hi, my name's Mike Smith. I'm an attorney from Baltimore. The problem I have with the 5-4 decisions, regardless of whether they come out for or against the position that I favor, is that it creates the impression that an asset that the court has had over the time of being nonpartisan is evaporating. And I'm wondering whether the court is being affected by some of the unwillingness to compromise that we see in other branches of the government. I mean, you can almost predict how the 5-4 decision is going to come out, with some minor exceptions. And that's the question I have, is whether these justices are unwittingly creating the impression that they're part of the problem in terms of the willingness to negotiate and compromise, so you don't have 5-4 decisions.
David, you invoked Bush v. Gore. Were you suggesting, as the question suggests, that this was a turning point as far as any concerns about whether the court's viewed as partisan or not?
I don't think it is, but I know a lot of people that do. But so I just threw it out there. But I think that I don't think the 5-4 decisions, they just happen. That's what happened. That's math. It's almost necessary. There's always been that kind of contention on the court and disagreement. I do think there's a fair criticism of the court generally that it acts as 9 individuals and less as a unified court. You don't have the collaboration among the justices like you do sometimes in lower courts. They don't communicate with each other before oral argument. Oral argument's really the only time they try to persuade each other before they vote, which makes for a weird dynamic for the advocate when you're arguing. I'll just real quick. I had a case several years ago that involved. This is a real exciting issue. What the discount rate should be in a Chapter 13 cram down proceeding in the bankruptcy code. I don't think David was covering that one for the LA Times that day.
I need a dictionary.
But you just pick a rate, right? The courts were divided. Just pick one. The Supreme Court split 4-1-4, each picking a different rate, and couldn't even have a majority opinion in a case like that. That's, in my view, that's kind of pathetic.
The question you asked, did you say that was the term you used an asset? Eric, could you get the microphone back to her? Did you say the court loses an asset?
Yeah, I think
What are you describing there? Are you thinking in terms of, is it a mystique or a credibility factor? What is
I think it's been a perception, until recently at least, rightly or wrongly, that the court is driven more by a more principled analysis as opposed to partisan considerations. And when you look at the decisions they've made, these 5-4 decisions on really notable issues, where you can almost predict the composition of the group, it seems to me to suggest, or could suggest, that these partisan considerations are creeping into their analysis, and that they're becoming part of the problem, where they, even among themselves, they can't negotiate a compromise decision because they're so hell-bent on sticking to their guns in terms of their ideology.
Well, that was-
I'd like to see a lot more 6-3s and 7-2s and
Is
so
there a
forth
yearning
than
for good old
5-4s.
days that never existed in this regard?
Well, so first of all, I would say that I think the court has always been a political entity, and maybe we kind of underappreciated that in the past. I think the appointments process, the confirmation process, has exacerbated this because the same interest groups that are bringing these cases to get these hot button decisions are the ones who are either sort of nurturing the careers of people who are making their way up through the appointment process in the federal system. And then the confirmation battles, become very, contentious because of, these competing viewpoints. But there are some, I was crazy. I went out on a limb and I said Roberts would vote to uphold the Affordable Care Act. Now, I was wrong about the theory under which he did it. But I really thought that he could see that that was a moment in time where you have this incredibly huge public policy initiative, and that there had to be a way to let the political branches sort of try it out if they wanted to. And I think he probably did it holding his nose the whole way, but he got a decision that kind of let the law go forward. And that their decision didn't become the issue after the fact. And I think similarly there was the one on the, the one this term that I'm blanking on, but it'll come back to me, where I think that they are able sometimes to kind of come to the affirmative action case. I'm thinking, yeah, that's what I'm thinking about. For the Fisher case, where they didn't throw out the Grutter precedent, they sent it back to have the lower courts take another look at the facts. But they didn't, throw this bombshell into the legal system. So I think they're still capable of doing that sometimes.
That's what Chief Justice Roberts said when he came into office, that he was concerned about exactly the same thing. 5-4 majorities, making the court seem too partisan, too political. And I think he would tell you he's tried, and sometimes it works. What he tries to do is sometimes, is there a narrow way to decide this that a lot of us can agree on and avoid a big ruling, and sometimes it seems to work and sometimes it doesn't, and I think the point Renee said, I mean, the biggest single case in the last 5 years, it could have been a 5-4 partisan ruling, and he went out of his way to make sure that didn't happen.
I would say sometimes he tries, not always.
Right.
But if I could borrow a term from another profession, gymnasts talk about sticking the landing. I think what you wanted to ask is, did the court stick the reasoning? So it might seem to be a partisan lineup of 5-4. Does the reasoning make any sense? Is there any plausibility to it, or is it so obviously a pretext for an outcome that it affirms your concerns?
Okay, who's next? Right down here, please. Let me see who has questions in mind. Raise your hand now, just so we get an idea, so we'll know where to go next. Okay, thanks. Yes, hi.
Hi, my name is Murad Egbal, previously at the University of Baltimore Center for International and Comparative Law, now with Plasmera Technologies LLC. The question I have reaches back to the term on the court by Justice Brennan, who often was described as a consensus builder. And for all of the panelists, do you think that that role still is open to be filled, or has it fallen by the wayside in the context of the coming term as well as this most recent term? Is there such a thing as a consensus builder? Or is
Steve, you wrote a book, not the book, I can't say, but a book, one of
Thank
the
you.
books on Justice Brennan.
I mean, you know, Justice Brennan was a consensus builder on a court that I think had some attributes that are missing. Some of the things we've talked about already. I mean, particularly the Warren Court, those justices liked each other. They worked closely together. Even the justices that were on opposite sides of things, Brennan and Harlan, talked all the time and were good friends. They tried to work things out and reach more consensus. But, you know, Brennan, the consensus builder, succeeded because he got his own way most of the time. There wasn't any consensus when he was in dissent, which was often in the Berger Court and the early Rehnquist Court years. I don't know that anybody is effectively
You know, I would
playing
just-
that role.
Well, you talked about relationships. I wonder if there's something larger going on here, because that could have been the same commentary we've heard on Congress and the nature of those relationships changing.
No, I don't think it's a relationship thing. You'd be surprised how close the justices are. If any of you have seen this book that the spouses of the justices put out about Justice Ginsburg's husband, Benjamin.
Marty.
No, Marty.
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 Thank you.
Marty Ginsburg.
Thank you, Marty. I knew that was wrong. It was coming out of my mouth. Marty, and it has all of. He was a famous cook. He has all of his recipes. It's very loving. It's very tender. It's a very close family. They get along remarkably well. Justice Kagan's been joking all off season here about going hunting with Justice Scalia and shooting her first deer. They're very close together personally. If you go back to the Brennan example, though, the thing I would point out is look at the backgrounds of the justices that served on the Warren Court and where they came from, and look at it today. And what you have is all former Court of Appeals judges that are trained and disciplined in a certain way of judicial decision making, that aren't used to making trade-offs and compromises and the like. They live according to the dictates of their own conscience in terms of their reasoning and their opinions. They don't trade horses, and that's very different from the background of those justices back then.
John, I think there's very much of a parallel between what's happened in Congress over the years and what's happening on the Supreme Court. If you went back in the 70s or 80s, there were, as we were saying, a fair number of moderate liberal, moderate conservative. Byron White was a Kennedy, Lewis Powell, Potter Stewart, John Paul Stevens. When they came on the court in the 1970s, they were not, you couldn't predict in advance where the cases would come out. Well, those are the kind of David Souter was probably the last of that. You know, he turned out to be a moderate to liberal Republican, was viewed widely as a mistake. So both parties now, just like the way the Senate has gone, the moderates have gone away. All presidents now, if you're a Democrat, you want to pick somebody who is reliably liberal on all the big issues. And if you're a Republican president, you're going to make sure you pick somebody who is a reliable conservative. You're not going to pick somebody like David Souter or like, the other examples I mentioned that are, somewhere in the middle. You don't really. So I think it's an inevitable situation. The court is going a little bit the same way of having people who come to the court with very different views.
Okay. Yes, sir. Hi.
Hi, my name is Andrew Simons. I'm an attorney here. Just a follow-up comment on that. On the 5-4, I don't think the issue is the 5-4. It's really what you're pointing to. It's the concern, I think, is usually 4-4 and how's Kennedy going to go. So it's not that they're 5-4 decision. It's just that it's so split. You know where 4 and 4 are going, and there's only one really in the middle.
Yes, and he's the sort of moderate Republican, the last of the sort of moderate Republican, right? He doesn't fit. Kennedy is different.
So I had a question, and maybe it's just too far out there, but there's other countries and have a high court that is made of more like an appeals court scenario where they have a lot more justices and they do it by panel on their highest court. Is there any currency to that? I mean, court packing has this bad sort of connotation from the Roosevelt, but if there were a way to expand the number of justices on the court so that you could have more of a panel type scenario, would that mitigate some of this, and is that even possible?
I had a number on this which I've lost, but I think in the last term, and you can check me on this, but I think it was in 10 5-4 decisions, Kennedy went right on 6 and left on 4.
So, and I say to you, the Ninth Circuit, in response to your question. So, you know, and I actually am not one of the people that's, you know, always trashing them. So, but you know, I think it's complicated. It could have the potential to exacerbate the problems in some ways.
You know, I think we overstated a little bit too, to be honest with you. If you look at just last term, there were many very interesting non-ideological 5-4 decisions. Let me give you just a couple of examples in the criminal context, involving the DNA collection, involving dog sniffs at your front door. There's a coalition of Scalia and sometimes Thomas. Actually, not often Thomas, but Scalia and the more liberal justices on a kind of more libertarian view of criminal process. There's you know, a variety of areas where you don't see strict, you know, ideological decisions. It happens, certainly, and it happens with some regularity. And it's, you know, important to remember, I think 63% of the cases last term were decided by a vote, a majority of 7 or greater. Maybe it's 6 or greater. You know, for how much they get into and how much work they do. And cases don't come to the Supreme Court because they're easy. You know, cases come because there's good arguments on both sides. I think it's pretty remarkable, actually, what they accomplish and what they do. It's in these more politically charged cases that I think I would agree with what was it David that said earlier. The court's not at its best in those cases. They feel a little more outcome determinative to me, and there's less of a. As an advocate, I dislike the arguing in those cases as much as others. I like to feel like I have some influence over the process, and at least pretend that I do. And it's very hard, I think, in those. Whereas, you know, you get a very difficult statutory question, and you know, you've got open minds there and very well prepared judges.
I just wanted to make a quick follow-up comment about Kennedy and the 5-4 decisions, because I think it's a very interesting point. The problem there is that you get this least common denominator kind of decision where there's actually only one person on the court who really entirely agrees with the decision, right? If the decision is written to please Kennedy and it's joined by 4 other justices, it's not really how they would have decided the case if it were entirely up to them. They're deciding the case that way in order for there to be 5 votes. But the next time you have to apply that principle to something else, it may not work. And I'm thinking it's not the best example, but the Casey abortion decision where Kennedy participated in writing the undue burden standard, but when they got to partial birth abortion a few years later, Kennedy said, wait, that's not what I meant by undue burden standard, and that was that. And so there's the risk that the 5-4 decisions don't really represent 5 votes.
You know, you could say the same thing. Take the healthcare case. You know, do you think the 4 liberal justices really thought it was a tax? If you'd sat through that oral argument when they were arguing about whether it was a tax or not, you wouldn't have thought so. But you know, I mean, that's just the nature of
Point
getting
being,
to 5.
there's a technicality they could hang their vote on.
Got to get to 5.
Well, the other thing I wanted to say is, how are times different now than before? We just have a very different society in which the, Brennan and those guys were operating, right? You know, they were all men. The society has changed in how it values a lot of different inputs into these decision-making processes. And so I think that, we consider a lot more than we even had to, or we thought we had to in those days. And so I think that it's just it's a more complicated world that they're operating in too.
Who's got the next question or comment? Anyone? Okay. Since there isn't one, and I'll take this last 2 minutes to ask you, I hate to do this, but it's an impulse that I can't resist. A prediction. Something that you would predict about this upcoming term, a surprise, anything of that nature. A quick one, if you have one in mind. Steve Wormiel?
Well, I think in the prayer case that I talked about, I think the court will make some new law and uphold the prayer practice by the town of Greece.
And is this a really significant ruling in the church-state paradigm over
Depends
time?
how the court reasons it, but I think it's potentially a very practical significance because there are lots of communities out there where this is a hot topic.
Okay, Dave Savage?
Well, it's not, I don't know if this qualifies as a surprise. I think the big decision of the court this term will turn out to be this contraceptive mandate case, because that's positioned for them to take that case in November or December and argue it in March or April. And I think those of us who follow the court will consider that the biggest case. It's a very rich case because it's got all those moving parts of the rights of the employer versus the employee, about religious liberty. Everybody can, is supportive of religious liberty. I do think in the end, it's the for-profit corporations, it's fine to say you've got some religious rights, but the law here is, does it substantially burden your freedom of religion to have an insurance policy? And somehow I think, even though the court sort of leans a little bit right, I think this is going to be a tough one. I think the government has a very good chance to win that case, because in the end, you think, as a for-profit corporation, is it infringe your rights to provide insurance for your employees?
Mm-hmm. Dave Salmons?
I was going to go in the same direction. I was going to say that the most significant case of the term has not been granted yet, but will be this healthcare mandate. I guess I would maybe throw this out, that I think the campaign finance case that we discussed will turn out to be a pretty significant case after all. That while there are some narrower ways the court could go, I guess
McCutcheon v. FEC?
correct. I think it will be viewed as a significant step along the Citizens United path.
Okay. Renee Landers. the
So I
last
guess
word.
I'll go, I agree with David about the contraceptive case. I think that's going to be a really big one. But I guess I'm going to say that on the recess appointments case, the Noel Cannon case, I think the court is going to say it's a political question and stay out of trying to mediate between the two branches.
Okay. Well, on behalf of my colleagues here at the Wilson Center, I want to thank our ABA friends, Mark Cohen, Kathy Hawk, and Mabel McKinney-Browning, for another terrific panel. Thanks to you for your time and attention, and I ask you to join me in thanking our brilliant panel for their discussion today. Thanks again. Good night.
No, that was fine. Good job, everybody.
Oh, that was fun.